Yeah, how would I get sentenced today then? So I plead not guilty?
No, if you pled guilty, you would be sentenced today. If you pled not guilty, we would set the matter for a pretrial.
Okay, yeah, I'll plead guilty.
Sir, are you currently on a probation violation at all?
Yep.
So do you understand that if you pled guilty today, and this was the basis of the allegation, that they would be able to use that violation or your guilty plea against you for the violation? Do you understand that?
Yeah, I don't really care.
Are you sure about that? All right, this is case number 26, 2036 FY, the people of the state of Michigan versus Gavin James Campbell. Sir, you met with somebody from Community Corrections and gave them some contact information, a phone number and an email address. Is that information accurate?
My information, yes, sir.
All right. And did you have the opportunity to meet with somebody from the Public Defender's Office?
Yes, sir.
I have a complaint that alleges that on or about May 22nd, 2026 in Greenwood Township of Wexford County, Michigan, it is alleged in count number 1 that you committed the offense of controlled substance possession of methamphetamine. That is a felony punishable by up to 10 years in prison and or a fine of $15,000. The people have also charged you as a second or subsequent offender, meaning that you have at least one prior you've got one prior drug conviction in your past. Looks like in this case, it's a possession of marijuana. That makes that 10-year felony a 20-year felony and the $15,000 up to $30,000. In the alternative, they have elected to charge you as a habitual offender fourth, meaning that you have at least 3 either attempted felonies in your past or completed felonies in your past. That makes that 10-year felony punishable by up to life in prison. Do you understand those charges and the potential penalties?
No, sir, I do not understand.
Okay. So do you understand that, at least based on the information the prosecutor has available to it, that it has charged you with the base offense of possession of methamphetamine? Do you understand that?
Yes, I understand that.
Okay. Do you understand that just the base offense of possession of meth is a felony punishable by up to 10 years in prison and or a fine of $15,000? Do you understand that?
Yes, sir.
Now, Michigan has certain sentencing enhancements, and there's 2 ways that a sentence can be enhanced in Michigan. One is if you have prior felony convictions in your past, and the other is if you have any prior controlled substance history in your past. And when I say 2 ways in Michigan to enhance, I mean in regards to your case. So do you understand that the prosecution could seek to enhance that penalty of 10 years? Do you understand that?
I understand.
So that first enhancement that they've charged you with is a second or subsequent offense notice. That's a notice that's used when you have a prior drug conviction. And so it looks like you were convicted of possession of marijuana back in 2018. So if they move forward with that enhancement, you could face up to 20 years in prison and or a fine of $30,000. Do you understand that?
I understand.
Well, Mr. Campbell, I want you to understand that just because these are the enhancements they're charging, that doesn't mean that that's what you're going to receive, because the guidelines come into play there, or plea agreements might come in that would reduce that. Do you understand that?
I kind of understand, yeah.
Okay.
This stuff's just so confusing to me.
One of the other enhancements that they're charged you with is a habitual offender fourth offense, and that is because you have prior felonies in your past. So the prosecution is saying that you have at least 3 either completed felonies or attempted felonies in your past. And it looks like they're alleging that in 23 you were charged or convicted of an attempt police officer assault, resist, and obstruct. And in 24 you were convicted of larceny of a firearm and assault with a dangerous weapon. So those 3 felonies then allegedly makes you a habitual fourth, which makes that 10-year felony enhanced to a life offense if you're convicted of the fourth. Again, the guidelines will come into play there. Do you understand that?
I understand.
Now, the other thing I want you to be aware of is that they cannot move forward on both of these enhancements if they decide to take you to trial, meaning that the case is not resolved another way. They would have to choose one of those enhancements over the other. They could not try you on both of those enhancements. Do you understand that?
No, I don't
So
understand.
if you went to trial, they could not try you on both the second subsequent, so the prior drug conviction, or the enhancement that deals with your prior felonies. They would have to choose one over the other. Do you understand that?
Okay. I understand.
That makes sense? So I know I covered a lot. I covered a lot there with you. Do you have any questions to me about what you've been charged with and what the potential penalties are?
No, sir.
Historically, counsel, I show in the defendant's past in 18 that possession of marijuana, also an operate without security, in 21 a retail fraud third, in 22 a failed to report an accident and an assault and battery, in 23 an attempted resist and obstruct, 24 larceny of a firearm, felonious assault and joyride, in 24 an attempt to resist and obstruct, in 22 a retail fraud third, and in 24 an illegal entry. And the praxis scores him at a risk level 4. Any comment regarding bond, Ms. Fiorvento?
Thank you, Your Honor. We would respectfully request a personal cognizance bond, or at least a low 10% bond here. The praxis score is at a 4, which would recommend release with conditioned supervision for a nonviolent felony. He reports that he has lived in this area his entire life, that he is working, and that his girlfriend is here and he's quite close to her, so it presents him as low risk of flight. He is willing, as for public safety concerns, he is willing to abide by whatever terms the court thinks necessary to ensure public safety.
Thank you, Ms. Lawrence.
Thank you, Your Honor. I do think a monetary bond would be appropriate in this case. This is a serious felony. He is facing some serious time, given this is a habitual offender fourth offense notice. I would ask the court to impose random drug testing, given the nature of the charges. On top of that, he is on parole, to my knowledge, and he is using controlled substances while he is on parole. So I would ask the court to impose at least a $10,000 cash surety bond, as well as the random drug testing. Thank you.
Ms. Lawrence, do you know, is there a parole hold on him?
I believe so. Indicated in the report that I do believe.
Corrections, are you aware, does parole have a hold on Mr. Campbell?
Yes, Your Honor.
All right. All right, given that there's a parole hold, and I believe statute 7656A says that because there's 2 prior felonies within 5 years, I do have to set a monetary bond. I'm not taking into account the fact there's a parole hold and setting the monetary bond, but I do believe a monetary bond is required in this matter. However, the fact that he is on parole when these offenses are alleged to have occurred, and the nature of the offense, I believe a monetary bond is appropriate. I am going to set a $10,000 cash surety bond with the conditions, Mr. Campbell, that you appear as ordered, keep your contact information current, not leave the state without permission, and to commit no new crimes. I'm also ordering that you not consume any illegal controlled substances, including recreational marijuana, and you'll be subject to random testing for that as well. Mr. Campbell, do you have any questions for me about your bond conditions?
Cash, 10,000 cash surety. I'm not going to be able to. I don't have help this time.
So if
What if I just
we need to
plead
do
guilty today?
No, I don't want you to do that, because I feel as though you feel you're pressured to do that. So, and then if you plead guilty, I understand that. So, sir, so you've requested the appointment of an attorney. So we'll make sure that the attorney meets with you. And if they feel as though after meeting with you, there's a need to file a motion for bond modifications, they know how to do that. And then we'll go from there. Okay.
So what happens now?
Well, next next week, you'll have a probable cause conference. That's where they're going to see if there's a way to resolve it. And then probably the week after, you'll be set for a preliminary examination. Now, that doesn't mean that certain things can't happen in between there, such as bond modifications or things regarding treatment, that sort of thing, but
I need treatment, sir. I need.
so,
really
Mr. Campbell, I'm going to ask you to talk to your or not your probation officer, your attorney about that, because even if I say today you could go to treatment, you still have a parole hold on you that's going to stop you from going to treatment. So until things get worked out between parole and your attorney and this court, it's not going to do any good for me to release you to treatment because you'd still be remaining there. Mr. Avento?
Thank you. I was just standing to caution the defendant here that someone from our team will be in to meet with him soon. We'll address those concerns. Right now, I said it could be used against him, and I would respectfully request him to wrap up. Someone from our team will be in to meet with him soon.
All right. So, Mr. Campbell, at some point in the near future, it sounds like somebody from the public defender's office would be in to meet with you about your options moving forward, okay?
Okay.
All right. Next to Raymond, jail?
That's pretty much. Fuck you.
Our last one is Medina, and it shows that he has a PR bond. Do you still want to see him?
This is case number 262057 SM, the people versus Devin James Medina. Did you have the opportunity to meet with somebody from the public defender's office today?
I think they showed up, I didn't speak with them.
Okay, you chose not to?
Yeah.
All right. I have a complaint that alleges that on or about March 25th, 2026, in the city of Cadillac in Wexford County, Michigan, it is alleged that you committed the offense of stray dog. That is a misdemeanor punishable by up to 3 months in jail and or a fine of not less than $10 nor more than $100. Do you understand those charges and the potential penalties?
Yeah.
You do have the right to be represented by an attorney, and if you could not afford one, one would be appointed to represent you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of one?
No.
Do you want to represent yourself then? Is that?
I guess so. I didn't know if is this really gonna be, it's really gonna be a thing? Like,
As of right now, that's what the prosecution has charged you with. So you've got 3 options. One is to hire an attorney, one is to represent yourself, or the other is to request the appointment of a public defender. How do you want to proceed?
I don't know. I guess I'll represent myself.
All right. Before we do that, I have to make sure that your waiver of an attorney is knowing and voluntary. So I have a form I'm going to read to you here. I guess, how many years of education do you have?
2.
2 years beyond high school?
No, 2nd grade.
Went through 2nd grade?
Yeah.
All right, Mr. Medina, this form says that I am the defendant in this case, and the judge has explained to me, and I understand that I have been accused of a crime, and I have read or have read to me the charges against me, and know the minimum and maximum possible sentences, the nature of the charges, and that there may be lesser included offenses, defenses, or mitigating circumstances. That I have the right to be represented by a lawyer at all stages of this process, and the court will appoint one for me at public expense if I cannot afford one. That I had the right to consult with a lawyer that I hire or that the court appoints. That I had the right to act as my own lawyer. That if I represent myself, I will be held to the same standards of law and procedure as a lawyer and not get any special treatment from the court. That the risks of being my own lawyer, including that a lawyer has skills and expertise that I do not in preparing for and conducting a criminal defense and trial, and the state does have an experienced lawyer. Unlike the prosecutor in this case, I will be exposed to the dangers and disadvantages of not knowing the complexities of jury selection procedure or how to preserve my appeal rights. That because of these things, it can be unwise to act as my own lawyer. I knowingly and freely waive my right to the assistance of an attorney and choose to represent myself. I do not want to hire an attorney or have the court appoint one for me. I have no doubt about my decision. I have 2 years of education. I read and understand the English language. I am mentally sound. Having gone through all that, you still wish to represent yourself?
Yes.
And you can read the English language sufficient?
Yeah.
All right. The court is, I believe the waiver is voluntary and knowingly, so I will allow the defendant to represent himself. Mr. Medina, you have a couple of options available to you today. One is to plead not guilty. If you pled not guilty, we would set the matter for a pretrial, which would give you the opportunity to discuss this case with the prosecutor to see if there's a way to resolve it. The other is to plead not guilty. If you pled not guilty, we would set, the other is to plead guilty. If you pled guilty, the 3-month misdemeanor would enter on your record and you'd be sentenced today. Do you understand those two options?
Yeah, how would I get sentenced today then? So I plead not guilty?
No, if you pled guilty, you would be sentenced today. If you pled not guilty, we would set the matter for a pretrial.
Okay, yeah, I'll plead guilty.
Sir, are you currently on a probation violation at all?
Yep.
So do you understand that if you pled guilty today, and this was the basis of the allegation, that they would be able to use that violation or your guilty plea against you for the violation? Do you understand that?
Yeah, I don't really care.
Are you sure about that?
Yeah.
All right, Mr. Medina, will you please raise your right hand? You solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth.
Yes.
All right, you may put your hand down. Mr. Medina, has anybody promised you anything in order to get you to plead today?
No.
Has anybody threatened you in any way?
No.
And is it your own free choice to plead today?
Yes.
Ms. Lawrence, are you aware of any promises, threats, or inducements?
Oh, yeah.
Mr. Medina, I know you were on probation at the time. Were you on bond in any other file?
Not that I'm aware of, Your Honor.
All right. Do you understand that you have a right to a jury trial, the right to have witnesses called for your defense at trial, the right to cross-examine all those witnesses called against you, the right to testify or to remain silent, the right not to have that silence used against you, the right to be presumed innocent, and the right to be proven guilty beyond a reasonable doubt? Do you understand all those rights?
Yes, Your Honor.
Most importantly, do you understand that you do have that right to a jury trial, and that by entering a guilty plea today, you'll be giving up that right and you won't have a trial of any kind? Do you understand that?
Yes.
And are you waiving your right to a jury trial?
No.
So you want a jury trial?
Yes.
So if you wanted a jury trial, that would be a not guilty plea, and we would then set it for a pretrial.
Okay, we'll do that now.
All right, we will then set this matter, we will enter a not guilty plea, and we'll set the matter for a pretrial. That's where your attorney and the prosecutor will get together to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of your appearing at future court appointments and the threat that you pose to the community. Mr. Medina, based on what I've seen today, I'm not entirely convinced it's going to be in your best interest for you to represent yourself. So what I'm going to do is I'm at least going to request that the Public Defender's Office meet with you and see if we need to change your request for an appointment of an attorney, okay?
Okay.
So we will set the matter for a pretrial. You do have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Ms. Fervento, I know you did not meet with Mr. Medina, but do you wish to weigh in on bond?
Thank you, Your Honor. We do have a praxis score, which is 3 to 6, but considering that it is a dog stray, Your Honor, we would respectfully request a BR bond. Thank you.
Thank you. Ms. Lawrence?
Your Honor, the praxis does indicate he has 12 failure to appears, which is extremely concerning to people. I think that does go to show he's clearly a flight risk. While I do understand it is a low-level misdemeanor, I will respond to the discretion of the court.
Thank you. I do see that the fail to appears are there, but in the end, we're dealing with a 3-month misdemeanor. So the court is going to release Mr. Medina on his own personal recognizance, which is his promise to come back to court. Mr. Medina, if you do get out because you don't have a way for the Public Defender's Office to reach you, if you do get released from jail, you're going to want to contact them, even if it's walking over to their office, to meet with them, all right?
Yes.
All right, thank you. Thank you, jail.